I would now like to introduce today's speaker, Janice Lee Shen. Janice is the newest addition to the Cunningham Legal team and is based out of our Woodland Hills office. Janice is part of our trust administration team, and today she's going to share some of the common mistakes made by trustees and how to avoid them. So without further ado, I'd like to kick things off by welcoming Janice. Janice, over to you.
Thanks, Jennifer. Good afternoon, everyone. Thank you for joining us today. Like Jennifer mentioned, my name is Janice Lee Shen, and I am one of 9 living trust lawyers at Cunningham Legal. All of our attorneys are licensed in the state of California, and some are also licensed out of state as well. I am one of the attorneys here that primarily focuses on trust administration. What is trust administration? A lot of people ask me, what is TA? So trust administration, I'm going to refer to it as TA for short. Once a trust is set up, typically the trustor or trust maker is in charge. At some point, the trustor, because we are all human, will not be able to manage his or her own finances. So I primarily help people who are appointed to manage someone else's trust assets. I have been fortunate to have helped many clients, whether they're responsible for a trust of $500,000 in assets or $50 million in assets. California probate code, which applies to all trustees, the probate code applies to whether your estate is in the high net worth or less than 500,000. So I will be discussing the top mistakes trustees make and how to avoid them. So before I get into the actual material, please take a moment to read the next slide. This is really important because you will be receiving valuable information today, but not actual legal advice. Legal advice is what you receive when meeting with an attorney one-on-one. So I am not giving you a presentation on how to do this by yourself. I highly recommend that at the end of the webinar, you stay tuned for your qualification for a free phone consultation with either myself or another attorney here at our firm, so that you could actually obtain legal advice. So with that being said, let's begin. The role of a trustee. So what is a trustee? A trustee is a person who has the legal authority to manage assets for someone else. Typically, a trustee is actually appointed in the trust document by the trust maker. So, for example, when I meet with clients that want to establish their living trust, it really amazes me how clients don't have a laundry list of people they trust. So, in terms of being appointed as a trustee, that person should really take a minute to think about how and why this person was appointed. So when a client establishes their trust, they really have probably a handful of people they really would feel comfortable sharing financial information. And so the role of trustee is really, really powerful, and it's actually a privilege to act as a trustee. So let's keep that in mind. So I always tell the trustees, please treat people like how you would be treated, because you're actually managing the actual assets for someone else.
Okay, well, it's time for our first poll question, which is a 2-part question. The first question is, are you currently acting as a trustee for someone else? And the response options are yes or no. Please take the next 15 seconds to make your selection, and then we'll go ahead and share the results. Okay, just go ahead and take the next 15 or so seconds. Okay. Oh, it looks like most of you have responded, and we're going to go ahead and share the results. And it looks like about 54% of you had said, no, you're not currently acting as trustee. Okay, so the second poll is actually for those who answered yes to the first question. We are asking, if you're acting as a trustee, have you consulted any of the following professionals? Please choose every option that applies And the response options are CPA, tax preparer, attorney, financial planner, or I am not acting as a trustee. You could go ahead and take the next 15 or so seconds. Okay, it looks like those results are coming in quick. Okay, we're going to close out the poll, and it looks like, again, most of you have answered with I am not acting as a trustee. So Janice, so I'll hand it back over to you.
So for those people that are not currently acting as a trustee, I think you're being very prudent. So whether you've been appointed or not, the fact that you're on this webinar shows me that you are educated and sophisticated to realize that you shouldn't take on the role of trustee without actually knowing what that involves. So our next slide really gets to that point. So before you agree to accept the position as trustee, you should really understand what your duties are, what your responsibilities are, and what your legal obligations are. I just actually had a client the other day give me a call who already knows that he's been named as a successor trustee, and he has not formally accepted his role because there are already a lot of issues with some of the beneficiaries that are already disagreeing on certain things. And so that trustee is, just like the people on this webinar, really prudent to understand his role. So I will be meeting with him to go over that. What's really important and what's fascinating that people don't realize is that just like a physician and just like an attorney, a trustee actually has a fiduciary responsibility to benefit and to work on behalf of the trust. So if that trustee drops the ball, that trustee may become personally liable for the damages and harm caused. So as trustee, you're really running with the ball, then people are depending on you. So don't drop that ball. If you do a bad job, you can be personally liable. You might end up hurting people, and really that's not what we want here. So with that said, let's actually go on to the next slide and discuss the top mistakes that trustees make and how to avoid them. So when I have a potential client call me, what happens is that person tells me, you know, we were at the hospital and the trust maker said to me that he or she wanted this. Even though the terms of the trust differ, this is what mom or dad really wanted, and I have witnesses to can account for that. And so I always tell those types of clients that it's really important for us to take a minute to actually locate the original trust documents. If we can't locate the actual original documents, we could also locate the copy, because sometimes the copy will suffice. And in very, very rare situations where the trust makers really made their intent known that differ from the trust terms, yes, it's possible that we could honor those intentions. Sometimes we'll require a court petition and all the beneficiaries signing off and consenting, but the trustee's role is not to make that decision unilaterally. It's really important that the trustee understands what his or her limits are. So the trustee really has to use the right trust document, understand the trust terms, and follow the decedent's wishes. So for example, I had a client that I met with about a year ago that decided that it was a good idea to get rid of all of mom and dad's possessions in the house, because that trustee decided it was probably not valuable and it would be best to go to charity. Well, that trustee didn't realize that there were actual provisions in the trust to where those assets should go. So it's really important for the trustee to meet with an expert attorney to review the terms of the trust, because the terms of the trust are written in legalese. It's really important for the trustee to meet with the attorney and go over such important documents such as a personal property memorandum. So it's really important that we follow the terms of the trust. The next mistake commonly made by trustees is not communicating with beneficiaries. A trustee needs to provide reasonable information to the beneficiaries. So a lot of times the trustees that I work with want to remain transparent and want to do a good job, but they also want to keep secrets from the beneficiaries, and that really is not a good idea. So the trust really requires the trustee to keep the beneficiaries informed of what's going on. A lot of times people don't realize that when the trust maker becomes incapacitated or is unable to manage his or her own assets, it's really important to get other family members involved, not because the trustee is declining or not wanting to act as trustee, but it's really important to get the family's input where mom is going to be living, where dad is going to be living, whether it's a assisted living facility, a boarding care, and it's really the trustee's ultimate decision. But I think from our experience, it doesn't hurt to get the input of the other siblings because it's really a matter of communication. So that's really key. Oftentimes too, when a mom or dad or the trust maker passes away, letting the beneficiaries know of the death is really important. Sometimes beneficiaries don't realize that there's a death, and it's really important for the trustee to communicate with the beneficiaries. So trustees should not avoid that. The next mistake commonly made is inappropriate spending and expenses. So the golden rule that everyone should remember is you should treat yourself as you want to be treated. In that same regard, you should treat the trust funds that the trustee is responsible for as if it were your own. That does not mean that the trustee should take the trust assets and then commingle them and put it into his or her own personal account. That is not what I mean by treat this money as if it were your own. What I mean is that the funds are there to really benefit the beneficiaries, because that is what the trustor intended. What the trustee cannot do is, use all this money to benefit himself or herself. The trustee cannot, spend money to benefit one beneficiary and favor the other. That is inappropriate. One of the things that's very common is when a trust maker passes away and the family members want to either have a funeral or a memorial service, and sometimes trust makers don't even want that. So it's really important to look at the terms of the trust to see what type of expenses the trust allows for. And if the expense is appropriate and reasonable, the trustee is able to pay for that expense and actually reimburse himself if the trustee is unable to get access to the trust account immediately. So that's really important. It's also important that the trustee keep a list or an accounting of all of the funds that were used to pay for things like death certificates or the memorial service, or if the house is being sold, making sure that all of those expenses are accounted for, because eventually the beneficiaries must receive that disclosure information, and the trustees will have to itemize all the expenses. The next mistake commonly made is errors in trustee compensation. So a lot of times I have clients come in and I meet with them for about an hour, and we go over essentially the terms of the trust, the trustee obligations, and what Cunningham Legal can do to assist the trustee. And during that consultation, I explain how California law allows for trustee compensation. Now, it's funny because sometimes clients will say to me, I was the trusted son or the trusted daughter, and so I am taking on this obligation free of charge because I want to honor my mom, or I want to honor my uncle, and I'm not going to take a fee. And so I almost always tell them, I completely understand, I respect your decision. My role here as an attorney is to explain to you what the law is, and explain to you the risks of, the decisions you make. but please, please, please start taking a timesheet of the time that you're spending speaking with an attorney, speaking with a CPA, going to the mortuary, talking to the beneficiaries, because I promise you that the time that you're putting into the actual administration will be not what you imagine. And so almost always towards the end of the administration, I have that same client call me or meet with me and say, you know, the first meeting, I told you that I'm probably not going to take a fee, but the beneficiaries or my siblings don't appreciate or have not appreciated all this time that I've spent while I'm working full time and I'm taking care of my family. And so what is the highest fee that I can charge for compensation? And so that's very common. And so what I have to emphasize is that the trustee cannot take a high fee. So there's no bright line rule in California, but there are trustee limitations county by county. So one of the benefits of meeting with one of the attorneys here at Cunningham Legal is that we could look at the county that you live in and that you're serving in and give you what that actual county reasonable rates are. So here in LA County, I've seen anywhere from $35 to $65 an hour, and it's really important to distinguish what the trustee will be doing. So for example, the trustee is not getting paid or should not be getting paid $50 an hour to take out any personal items from the home. So that's something that you can delegate and probably not will be reasonable if you're charging the trust $50 an hour to actually go through the trust assets. So it's really important for the trustee to keep a timesheet, a time log, and really figure out how much effort, or how many hours the trustee put into, because some counties, such as Napa County, you are allowed to take a certain percentage of the trust. So usually that's limited up to about 1%. So many trustees actually sometimes decide on not receiving compensation because any compensation must be reported on the trustee's personal tax return. So that is actually income. So it's really important for the trustees to figure out what the compensation is and to take the compensation and disclose that information. So if you hope to be compensated for your time as trustee, discuss that with an attorney early in the process.
Okay, great. Now we have a question from Jerome, who is currently listening in, and he's asking, don't trusts sometimes specify the terms of trustee compensation?
That's a great question. So yes, there are some trusts that I've seen where it limits the trustee's compensation. For example, I've seen a trust where it says it should be no more than 1%. But I will tell you that the California Probate Code controls, and so usually most trusts that I've seen will have some limitations, but it's the California Probate Code that controls.
Thank you so much for answering that. Okay, everyone, it's time for our next poll question. And the question is, do you expect to act as a trustee in the future? And the response options are yes, no, or unsure. Please go ahead and take the next 15 seconds to make your selection, and then we will go ahead and share the results. Okay, we're going to give you another 5 or so seconds. All right, we're going to close the polls, and it looks like most of you have responded with yes, you do expect to act as a trustee in the future.
And that's great. I mean, again, it sounds like most of you are the trusted child or the trusted family member or the trusted friend. It's really important. It sounds like, you've been doing something right. So, a lot of times clients that I meet with or families that I meet with come in and, that role of trustee should be highly regarded. It's one with authority and a lot of power, but with power, there are a lot of responsibilities. The next actual mistake that we commonly see is the mistake of mismanagement of assets. So one of the duties a trustee has is to actually gather and inventory all trust assets. Sometimes that's really difficult because once a decedent passes away, the decedent, doesn't typically have a list of all of the assets, because nowadays we have, a lot of online banking without access to the personal username and password. It's very difficult for the trustee to locate that. So how do you actually obtain this information? So the first step would be the trustee should investigate and go through the actual trustor's physical mail to find either bank statements or 1099s. That's really important. The actual trustee should also consult with an attorney to make sure or to determine whether that trustee has a digital asset authority. That's one of the benefits of working with our firm, because we also include that in our trust provisions. It's very standard. Some trusts don't. Another important step is for the actual trustees to obtain a copy of the decedent's last tax returns, because it's very helpful when you actually see someone's tax returns, because in the actual returns, it lists, sometimes where all the investments are coming from in the K-1s. So that's really important. What the trustee should also keep in mind is that depending on the date of death or the date of incapacity, that is actually the starting point in which the trustee will be legally responsible and owe a duty to the beneficiary. So from that day forward, again, whether the trust maker becomes incapacitated or once the trust maker is no longer here, that's when the trustee, usually that's when the trustee accepts his or her formal duties. And that's when, at that point, the trustee should be managing the trust assets. What is actually a trust asset? So this common scenario happens all the time, where I have a trustee come in and say, right before my uncle passed away, he decided to sell his house, and he wanted to sell his house because he was gonna, go into a retirement center and live there. And so after he sold his house, he wanted to make sure that someone had access to the account. So, I'm on the account. And so when I see that account statement, I see sometimes that the decedent put the trustee's name on the account and didn't really hold it in trust. And so it's really important for that trustee to meet with an attorney, because when a house is sold right away and that house was a trust asset, meaning the house was titled under the trust, but right before or right after the sale, the funds were then transferred to a joint account, is that considered a trust asset? So California law just recently had a case occur that the courts basically said it really depends on the trust or will instrument. We really have to evaluate and look at the trust terms and evaluate what the decedent's intentions were, because what we don't want is the trustee to be in a conflict of interest position where that trustee believes that that asset should not be a part of the trust and that trustee receives that asset. So it's really important that the trustee evaluate, inventory those assets, because we don't want the trustee to be sued for taking a trust asset out of the trust, because that trustee can be responsible and be punished for taking trust assets. Another common question that I am asked and that I see is when a trustee becomes in charge and wants to add a spouse to that account, just in case something happens. That is a big no-no. You cannot do that. A trust has to remain in the name of the trustee under the title of the trust. It can't be in a personal account. So that is actually a mismanagement of trust assets. And I also want to point out that this is one area where a lot of attorneys are not thoroughly advising their clients. So at our firm, we emphasize the written financial plan. And so for those trustees that don't understand or don't know what a written financial plan is, the law requires a trustee to have a plan. And one of our attorneys here at Goodson actually did a separate webinar on how to write an asset management plan. And so I highly recommend that you listen to that, because it's really important for the trustee to have a written plan and avoid any sort of personal liability. Another mismanagement of assets that we typically see is when the trustee does not sell the family home in a timely manner. Now, there is no bright line rule on the actual date when the house needs to be sold, but it's really important to keep in mind that it must be reasonable. So for example, 1 year after someone passes away is probably, if the trustee is selling the home after 1 year, that's probably a breach. And a breach basically means that the trustee can be removed and can be financially liable for that breach. And so, you know, losing a parent, losing a loved one is a very emotional process. And we here are very mindful of that. We want to respect the mourning process, but we also want to be mindful of the legal responsibilities a trustee has. And another way that a trustee commonly mismanages assets is when the house is sold or when the house is transferred, the trustee does not properly notify the recorder's office. So that's actually an affirmative requirement that the trustee must notify the recorder's office. Just because a death certificate is issued doesn't mean that Social Security and the recorder's office is automatically notified. That is not what occurs. So that's really the trustee's responsibility. So every trustee must keep in mind that when you're selling property, whether it's stock or assets, that could trigger a capital gains tax issue. And so we really want the trustees to talk with professionals. The next mistake we often see is making premature distributions. So it's very, very rare for a trustee to make a distribution prior to 4 or 5 months once the trustee accepts the position. So here in California, there is actually a law that says once a trust maker passes away or once the terms of the trust become irrevocable, meaning no one has the ability to change the terms of the trust, the trustee has a duty to send notice to heirs and beneficiaries. So this is not just a do-it-yourself form, it's actually it's actually a notice that requires a certain font, a certain boldface. This is really important because the trustees should always get this done immediately. The reason for that is once you send that notice to the beneficiaries listed in the trust terms or heirs at law, and I'm going to explain what heirs at law mean, that starts the clock ticking for 120 days. So during that 120-day period, a beneficiary or an heir at law can contest the terms of the trust, but after that time has elapsed, it's very difficult or it's really impossible for someone to challenge the trust terms. So an heir at law differs from a beneficiary in that an heir at law is someone that is entitled to receive an inheritance, but for the trust. So if I have a client that comes in and he or she has 2 children, and that client wants to only leave behind assets for 1 child, that 1 child is going to be the beneficiary. Now the other child, even though he or she is not a beneficiary, he or she is considered an heir at law. And so for that reason, that heir is able to or should receive a statutory notice and is entitled to receive a copy of that trust. So giving that notice is very important. Trustees should not be making distributions prior to the 120-day period. What's also important is to determine whether the decedent used any sort of government benefits. So in California, that's really crucial because here Medi-Cal is very, very widely used. And so one of the things that the Department of Healthcare Services can do, and the Department of Healthcare Services actually manages Medi-Cal, is that the Department of Healthcare Services can put a Medi-Cal lien on the actual property. And so you should work with an attorney to determine whether there is a Medi-Cal lien on the property. So the trustee must give notice to the department and should wait until they get a clearance letter before any distributions are made, because what you don't want is to distribute the property and then find out later that there's a lien on the property. In that same regard, there are some counties that allow for the property owner to defer property taxes. So you also want to make sure that there's no property tax liens on the home, and that's really important. I had a situation where I had a trustee, wanting to make a distribution to all of the beneficiaries. Well, I explained to the trustee, well, let's wait for the 120-day period and let's see if there are any potential creditors. And, unfortunately nowadays, at-home care is very expensive. And I had a decedent who had a caregiver live with him and care for him. And unfortunately, that caregiver decided to actually sue the trust for unpaid wages. So again, these are important actual things to keep in mind, because you don't want to distribute trust funds too early on without really realizing the liabilities that are out there.
Denise, we actually have an audience question, but it relates to the last slide, and it's from Craig, and he's asking, you said not to take too long to sell the deceased property. How long is okay to wait?
It really depends. So my first question would be the market condition. If you asked me, back when unfortunately the market wasn't doing so well, it would be very reasonable to hold on to the property as long as you're making the property productive, meaning you should be renting it out. The trustee shouldn't be renting it out to his best friend for a very low rent. But commonly, anytime over 1 year is too long. So I will say if the trustee is going to sell the property, typically 6 months to 1 year is fine. Anything over 1 year is not a good idea. And another reason for that, not only because it's too long, is for capital gains tax purposes. So almost always what happens is when a trustee meets with one of our attorneys, we evaluate to see whether an appraisal is needed for that property. So here in California, with property being so volatile, we don't know, what the actual value will be, but a lot of our clients who've lived in their home for the past 20, 30, 40 years have seen an increased value of that property. And so we want to establish a basis in the event that that trustee sells the property. And when you wait too long, you have to get an appraisal done. And usually that's not just a realtor drive-by. Sometimes that works. Usually it should be a certified appraisal.
I have one other question from Rebecca, and she's asking if someone is not listed in the trust, such as annuities with beneficiaries, does it fall under these guidelines, part of the estate?
So there was a recent case about a couple of years ago called the Yucasset case. And so some trust terms state that upon my passing or at any time, the trust assets include all property, whether or not held by the trustee under the trust. So that basically means that first we have to look to see if there's Yucasset language, and again, that's just based on a case, California case, but we have to see what the trust term says. Second, we have to see what the annuity says, because sometimes with annuities, there is a death claim benefit. So depending on who the beneficiary is listed as will determine whether that's a trust asset or not. All right, so if that takes care of all the questions, what I would like to do is go on to our next actual mistake that I've seen very commonly is not hiring a tax advisor. So that's really, really key. So, when I have clients come in to meet with me, a lot of times there's a lot of anxiety in the air because the trustee is afraid that there's not enough funds to cover taxes, or the trustee is just not really feeling good about, either the trust terms or the beneficiaries. The first thing that I do is I ask the client, what his or her concerns are. And second, I always go over what I call the Rubik's Cube in my mind of taxes. So you must evaluate taxes as a Rubik's Cube. And the reason why I say that is because we have to evaluate the property tax, we have to evaluate the estate or death tax. Some people call that the inheritance tax. We have to evaluate income tax and capital gains tax. So our role as attorneys is to advise you to the best of our abilities. I am not a CPA, so if the trustee has a CPA or the decedent had a CPA, we are more than happy to work as a team and as a collaborative team for the trustee, but it's really important to evaluate the taxes. And so what I do is, go over our little Rubik's Cube of property tax, estate tax, income tax, and capital gains tax, and evaluate, and we are more than welcome, or we're happy to refer you to a CPA or a tax advisor. One thing to keep in mind is that when the trustee is actually looking at distributions in the future, the trustee needs to really look at what the decedent did prior to passing. So the problem is the trustee wants to make all these great distributions out, but the trustee may not realize that the decedent perhaps cashed out a 401k or an IRA a year before or right before passing. I've seen that happen, and it becomes an income tax nightmare on the decedent's final return, but we can manage and go through and make sure that that's properly paid out. It's also important to see what happened to any actual interest in business, because we want to make sure that we're minimizing or avoiding any sort of capital gains tax as well. So it's really important for the trustees to meet with the tax advisor, because you don't want to end up paying too much in taxes, but you also want to properly pay the tax owed. We don't want the trustees to be personally liable for that. So our last mistake is covered in our next slide, is actually failing to work with an attorney. So what I like to tell my clients or anybody that's looking to work with an attorney in the trust administration process is, one, you should work with an attorney that you feel comfortable with, but also the attorney should be experienced in trust administration. So a lot of attorneys practice estate planning, which I do as well, and all of our attorneys here as well. Estate planning is when the trust is established, and that's really important because we want to look at the trust terms. But trust administration is a process in which after the trust maker is unable to manage, so you should work with someone that has experience in trust administration. You shouldn't work with just your CPA or tax advisor. So I think CPAs are great, and I think you should work with a tax advisor. However, you should also work with the attorney, because sometimes CPAs don't see the legal responsibilities and obligations besides the tax deadlines. Another problem that I see with trustees is doing it yourself. So sometimes trustees come in and meet with me and say, I'm just going to do it on my own, and I know what to do. And then 3 months later, inevitably they call me back and say, I did this wrong, I did this, I'm getting these letters from the recorder's office. Oh my goodness, I'm getting a supplemental reassessment, for the property. So what I tell people is it's really important to meet with the attorney early on, so that you're not spending the trust funds to not only have the trust attorney look at what you did wrong, but also fix the mistakes that were done. So that's really, really important. Another important consideration is for the trustee to come in early on when perhaps the trust maker becomes incapacitated, because you want to work with someone that understands not only, the protection and the role of the trustee, but also be mindful of the trustor. So for example, I had a client that came in last year, and he was paying about $5,000 a month for the past 3 years in caring for mom, and she was at a facility. And he came in because he needed to sell the house and he wanted our help. Well, I was evaluating what he did, and unfortunately, I wish he came in 3 years earlier, and that's what he told me, because we were able to not only protect his role as trustee, but we were also able to help mom pay for her care using other resources. And so that's really important, because the trustee may not know that there are programs out there that will benefit the trust and protect the trustee as well. So you really should work with a trust attorney, because it's, liability is key here. Usually the trust terms allow for the trustee to pay for legal representation, and so trustees don't pay for that personally. Usually that's part of the actual trust terms. So in terms of Cunningham Legal, you really want to work with us. We have 9 attorneys statewide. 2 are actually state board certified specialists in estate and trust and probate law. 2 have taken the certified specialist exam and are waiting for results. And we have 2 attorneys that have LLM degrees. And that just means that it's actually a higher degree than a JD. And one of them is very, very skilled in taxation law, and the other is actually skilled in estate and trust law. So we are experts, and we really think that you should come in and meet with one of us. And Jennifer will be talking about how we could accomplish that. So in summary, please, please, please understand that 1, the trustee has a legal responsibility and obligations that he or she must fulfill. Just because you are ignorant of the law, a judge will not excuse that behavior. So we don't want the trustees to be in breach. Don't drop the ball. Please remain responsive to beneficiaries, and please be mindful that there are tax deadlines that you must abide by. So with that in mind, thank you for your time.
So we have a lot of we have a lot of questions coming through, and we have about a few minutes to go. So we want to be mindful of your time. So this is a great time to mention, and before we move on to the Q&A, that you as attendees of this webinar are qualified to receive a free phone consultation with one of our attorneys. Just reach out to us at team@CunninghamLegal.com or give us a call at the number you see on your screen, and you can go ahead and schedule that way, or if you have any general questions. Okay, so with that, we're going to answer some of your questions submitted during today's presentation. And as a reminder, you can continue to submit questions through the questions pane or through the chat icon. Okay, so the first one is from Steve. Steve is asking, what if a friend or relative is living with the trustor, caring and helping trustmaker in exchange for room or board? Can caretaker later sue trust on labor law basis?
And that's a great question. So if that person that's caring for mom and dad or the trustee is getting compensated for that, I would highly recommend that the the trustmaker meet with an employment attorney. I have seen the worst of the worst. So unfortunately, I'm going to say yes, the trustee has the trustmaker has a responsibility to report that to EDD. The trustmaker has the responsibility, to make sure that that's all being reported. In that regard, the person receiving the compensation also has a responsibility to report that, and so that person can be audited and penalized if that person is not receiving, or not reporting that income as well. So the room and board question is a very hot topic in California. I think that anybody that is receiving care needs to be very mindful of who they trust and who they let in their home.
That's great info, Janice. Thank you. So we have a question from Robin, and she's asking, earlier you mentioned something about the trustee and they need to agree. But if my trust defines my trustee and I had asked them first, then is this still up for discussion?
You know, that's a great question. So a lot of times when I'm meeting with clients and they name either, you know, a trusted friend or a family friend, you know, unfortunately, I hope people will stick with their word and promise and say yes. In California, just because you accept a role, because being a trustee is voluntarily accepted, that trustee could always resign or decline. So just because that person says yes now doesn't mean that that person can say no later.
Great. Thank you. Okay, so Rebecca, she asked a question before, but she has another one. Can you explain a receipt and release form?
Sure. So I I think you mean by receipt and release when after the the trustee becomes in charge and accepts his or her role, one of the requirements in California under California law is to provide a report and accounting to the beneficiary. That literally means that you have to let the beneficiaries know what were in the accounts as of date of passing or date of incapacity or the date the trustee became in charge. And literally, there has to be a report of everything that went in, went out. And typically, after that report is sent, the beneficiaries will sign a receipt and release showing that they agreed to whatever the trustee did for that time period, and that releases the trustee liability. So that is important. I will say that there is a 180-day period where once a beneficiary receives that report and accounting, depending on the trust terms, it can be shorter or longer. The minimum is 180 days, or it could be longer. The trustee then can rest assured that there will be no question in terms of that specific accounting. So there is another statutory period.
Okay, we have time for probably one or two more questions. So this next one is from Anita. In California, the law generally provides 1% fee for compensation. Is that typical around the country?
So I am licensed in California, so I want to limit that to for LA County and Napa County. That's true. Counties such as Placer and Ventura, the 1% rule may not always apply because it really depends on, for example, I had a situation where the only asset in the trust was a home, and the home was going to someone besides the trustee. And so in that situation, one can argue that it would be unreasonable for that trustee to receive 1% of the very, very valuable property when the trustee, just sold the home or transferred the home. So it really depends. So that 1% across the nation, yes, it applies again in certain counties. It's not a bright line rule for the entire state or the nation.
Okay, and this next one's from Michael. I sold my father's home at an appraised value. What capital gains problem can I run into?
So if that trustee sold the home at the appraised value, first I would say it really depends on the sale. So, if we were in a very volatile market, I would evaluate the time period from the date of appraisal to the date of sale. So very rarely, but it does happen, there might be an audit if the date of appraisal, let's just say, was 8 months from the actual date of sale. There can be an argument made that no, there was an increase, and the IRS could refute the date of appraisal. It depends if the date of appraisal was from a certified appraiser. It depends on the facts. But to answer your question, typically the answer is very little or no capital gains tax, but I would have to know more facts into the date of the appraisal and the date of sale.
Thank you so much, Janice. I appreciate you doing your very first webinar. This was a lot of great information. And thank you, everyone, for attending today's webinar, Top Mistakes Trustees Make and How to Avoid Them. We will answer all of the other questions submitted and we didn't get a chance to answer afterwards. We will send you an email with the answers to your questions, and we will get back to you within the next, at least 24 hours. So if you have any other questions, though, please email us at team@CunninghamLegal.com. You will receive a follow-up email within a few days with a link to view a recording of today's webinar. Just a note that our office is open until 5 p.m. this evening for those who have immediate questions or want to sign up for a free consultation. Our normal business hours are 8 to 5 p.m. Pacific time. On behalf of Cunningham Legal, thank you all for joining us today.